Laura Willenbring for the people.
Mr. Jackson, could you state your name for the record, please?
Shihab Jackson.
Your Honor, today is the date and time set for the probable cause conference. My client respectfully requested this matter be set for preliminary examination at the earliest possible date.
April 4th, 2023, 9 a.m. before me.
What happens before now and then with concerning bond?
You're out on bond now, Mr. Jackson. Is there some aspect that you want to have addressed?
Yeah, I have to. Well, it's Ramadan right now, and I have religious obligations as well as work obligations in general. And for some reason, it wasn't a drug case or have anything related with drugs. And I'm on the daily reporting thing. And I believe I may have. I think I missed mine yesterday. I don't mean to be in violation, but I'm just sort of struggling with that and confused as to why that is.
Your Honor,
if there's a way to lessen that, or like I don't see.
What looks like a routine probable cause conference quickly reveals a defendant who believes the courtroom should bend to his personal frustrations. The judge opens with standard procedure. The attorneys are respectful, and everything is moving normally. But the moment Mr. Jackson begins speaking, the tone shifts. He isn't listening to the process. He's testing it. Courts run on structure, not personal narratives, and right from the start, this defendant signals that he's going to challenge authority rather than work within it. This opening sets the stage for everything that follows. A man confusing explanation with entitlement, and a judge patiently giving him rope, perhaps more than he realizes.
that the tether aspect or the drug testing aspect actually be reduced in this case or dismissed in this case. As he stated, there is no drug aspect to this case whatsoever. And this just serves as an added burden on him.
He's on intermediate supervision.
I'm not sure why.
I'll handle it, Mr. Jackson. I got you.
As set by the magistrate back in the beginning of March. I'm disinclined to change that at this point. I guess I'm not sure why his testing, why Ramadan would interfere with his testing. I understand that he may have certain obligations, but I have other individuals who are engaged in the celebration of Ramadan who aren't having these issues.
Well, it's not celebratory, sir. I just fail to see the connection with the nature of my case and having to go out of my way.
He claims Ramadan obligations and work conflicts while casually admitting he may have missed reporting requirements. That admission alone should trigger concern, yet he frames it as confusion instead of responsibility. Courts hear genuine hardship every day, but what matters is tone and accountability. Instead of asking respectfully for clarification, he suggests the court's conditions are irrational. This is a subtle but critical mistake. Judges don't respond well to being challenged under the guise of misunderstanding. At this point, the judge is still measured, still listening, but the defendant is already drifting into dangerous territory by questioning the legitimacy of his bond condition.
There was some interference with what he had to do, but I'm not changing it. I'm going to leave his bond as continued. We can see him on the 4th.
Thank you, Adam.
So is it not possible to amend the drug testing, Your Honor? I understand is it just a...
Okay, so hold on.
Yes,
hold
sir.
on. I think I already said that, and I wasn't going to say anything. I will make, Ms. Willenberry, I'll make all the changes that you want. I'm just going to tell you something, sir.
Yes, sir.
I will do what I can for people. I am also very of those that work around me. I got a message that you were very insulting to my clerks. So you ought to be that I'm
Mr.
letting
Jackson,
you
stop talking.
I can't hear. I'm just seeking clarity, sir.
Mr. Jackson, stop talking.
I'm not talking, sir.
So
That's what you just did.
see, It's that attitude that's the problem. So what
Sir,
I'm going
I'm
to
a young
do
black
is I
man
will.
fighting for his
Jackson,
wife.
Oh.
The judge explains bond conditions clearly. They are not suggestions. They are promises made for freedom. Drug testing isn't about the charge alone. It's about compliance and supervision. The defendant doesn't like that answer and pushes back emotionally, framing the requirement as unfair and expensive. That argument rarely succeeds because bond is about risk management, not convenience. The judge's explanation is firm but fair, laying out the logic behind the system. This is a critical moment where the defendant could accept reality, comply, and move forward. Instead, he chooses frustration over strategy, and that choice begins to cost him credibility.
I understand. I'm not sure if there was a mute or something. I'm just making sure. I understand.
Okay, so you don't have to respond to everything that's said. You don't have to get the last word. That's not.
I'm not trying to. My life is on the line here.
All
That's all. That's all I'm.
Okay, you know what? You know what? Put some deputies at that door right now, right down there at the door. Because he apparently just called security to get him down at that door. Because apparently he doesn't want to listen to his attorney. He doesn't want to listen to me.
Sir, I'm just seeking clarity on the matter. That is all. I promise. I'm a black man in the system, just trying to fight for his freedom. That's all.
Okay, so am I. So
You're
don't
not
even
fighting
try
for your
it.
freedom.
Don't
sir.
even try it. Don't even try it.
Don't even try
Alan,
what,
get
sir?
down there.
Tyree
Get down
Lee
there.
was 14
Get down there, Alan.
beat black
Just
people.
get down.
The attorney respectfully argues there's no drug-related charge and asks for reduced testing. This is how you advocate, calmly, logically, and through proper channels. The judge listens, acknowledges the request, and explains why he's unwilling to change conditions set earlier. Notice the contrast here. Counsel speaks. The judge responds. This is how court works. Unfortunately, the defendant doesn't recognize that his lawyer is actively helping him. Instead of letting the process play out, he's itching to jump back in. This section highlights a painful truth. Sometimes the worst enemy in court is the person sitting at the defense table.
Mr. Brown, if you've got somebody down here, he can come in, he can see me in person. We'll wait for a prosecutor to get down here and I'll deal with this in person. I'm passing it right now, but right now he's being taken in because I'm not dealing with him. I'll pass this matter.
Sir.
Mr. Jackson, if you will just maintain your.
Does call the case of the people of the state of Michigan versus Jessica Lynn Kyle.
Mr. Ganatra, first assistant prosecuting attorney on behalf of the people.
Zachary Ward on behalf of Ms. Keel, Your Honor. Can we approach very briefly on this matter?
You really want to go into a room with me right now?
Your Honor,
sure.
I don't think.
Yeah, give us a bench copy.
The judge points out that others observing Ramadan are complying without issue. He isn't dismissing religion. He's separating faith from legal obligation. The defendant reacts defensively, correcting the judge's wording instead of addressing the legal issue. That correction, while emotionally driven, adds nothing legally and chips away at goodwill. Courts respect faith, but they require compliance. The judge makes it clear that inconvenience is not a legal basis for change. At this moment, the door for flexibility quietly closes, not because of religion, but because of repeated resistance.
And does exactly what all of you have been screaming at your monitors for him to do, and shuts up long enough for his attorney to defend him.
Court recalls the case of the people versus Shahab Jackson.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jackson. Mr. Jackson, would you state your name for the record, please?
Yep, Jackson.
All right. We're here. I set this already for preliminary examination, and it didn't seem to me, quite honestly, that the defendant was being cooperative with anything, and I didn't know what his problem was. And so I was considering revoking his bond and having him sit. But I would like to give him an opportunity or have counsel explain to me what's going on with this young man, because the behavior was unacceptable.
Your Honor, I've had an opportunity to talk to Mr. Jackson, and I want to start with that. We did talk about, and I was able to explain to him what contempt is considered in court. We went over that the definition is a willful act, omission, or statement that tends to impair the authority or impede the functioning of the court. In the course of our conversation, I learned that in 2015, so approximately 7 years ago, during Ramadan, Mr. Jackson was incarcerated and his grandmother died, and he was unable to get a pass, go to the services, spend any last few days with her. And so this time frame specifically is very triggering, but definitely with him being involved in court again. He has indicated that he would allow me to do the talking today to demonstrate just what he's doing right now. And so with that, we are asking that Your Honor give him another opportunity.
The judge warns the defendant about his behavior toward court staff and tells him directly to stop talking. Instead of stopping, he argues about stopping. This is courtroom quicksand. Every word makes it worse. Judges value respect for staff as much as respect for the bench. Interruptions aren't just rude. They disrupt the court's function. The judge's patience thins, and the warning becomes explicit. Silence here would have saved him. Instead, defiance disguised as confusion pushes the situation toward consequences.
Trying to overtalk me, and that ultimately, and you can tell him, Ms. Gaines, anybody that's been before me, that will never happen. And then, but what was so bad is the person that's trying to help you, Mr. Brown, is trying to get you to be quiet, and you kept talking. And I don't know where you thought you were going to get to, but I can tell you right now, you do that in my court, this is where it leads. I can't tell you necessarily that you're going to listen to your attorney, but you're certainly not going to sit up there and interrupt them. And I'll tell you, I've been doing this for a long time, and when I see somebody that's not listening to their attorney, especially somebody that's esteemed as Mr. Brown, and others telling you what to do, that's a person that's not going to listen to anything. I have to almost believe they're not going to listen to anything I'm telling them to do. Those are the people that end up getting themselves incarcerated. I'm then also very disturbed that you've got defense counsel, and then you're down at the prosecutor's office. I don't even know why you're down there. Well, you're trying to give them something or whatever, and you're trying to give them something, haven't told your attorneys that what you're doing. That doesn't even make any sense. It's almost like you want to get locked up. I will be honest with you, sir. I looked at the charges and see your previous record. I get what may have happened to you in 2015. I see the timing of it when I'm looking at your record, but then I see what you did afterwards. Whatever your thoughts are, you just got to do better. There is no reason coming in here today that this should even be occurring. Tell you what, I'm going to trust Ms. Gaines. Ms. Gaines tells me that I should give you another chance, and Mr. Brown told me the same thing, that I should give you another chance. These are these people you won't listen to, by the way. But if they tell me to give you another chance, I'll give you another chance. But I'm going to let you know you don't have any other opportunity with me to mess up. You mess up, I'm sending you. Am I understood?
That a yes?
I'm also going to add so I will continue his bond. He can be released to custody. I have the amended complaint. I am going to also add as a condition of his bond to be entered into lien that you are not to go within 500 feet, except if you're going to, well, that's outside of the 500 feet of the Washtenaw County Prosecutor's Office in downtown Ann Arbor. You understand that?
He's going to get it yesterday.
Pardon?
He's going to get it yesterday.
All right, very good. So we're adding that to lien. So I want you to know what that means.
If you're within 500 feet of their offices, police officers come on you, they can arrest you on that. So don't say you didn't understand, because
The judge clearly explains what be quiet means and warns of contempt and bond revocation. This isn't anger. It's control. The defendant keeps talking, insisting he's just seeking clarity. In court, clarity comes from listening, not interrupting. The judge now sees a pattern: refusal to accept instruction. Once that perception forms, the outcome becomes predictable. The system doesn't bend for volume or repetition. It responds to compliance. This segment shows exactly how fast a situation can spiral when someone refuses to read the room.